I saw one person post on LinkedIn like, "Oh, they're going to get rid of all the optional things." It's like,
there are no optional things. About?
Yeah, it's never been optional. And, and this was a person that underneath their name was, HIPAA consultant. And I'm like, come on, God.
Help me with HIPAA. Let's get it right. Protect your patients. Day and night. Donna and David, the experts on your side. Help me with HIPAA. Let's get it right.
All right, folks, we're going to take you down a long dirt road and talk about the HIPAA privacy changes. They're coming soon, maybe. And the reason why we want to talk about it now is because it was like a long time ago. We talked about it before. And so now it's coming back around. Possibly it's going to be something that happens this year. And I think we need to talk about it because not too many people are going to go back to episode 291 or something like that when we first talked about it.
That's right.
So yes. I think for some of you, this is a refresher. And I will say that for me, it will be a refresher also because it was so long ago. It's like, what did we even talk about on this thing?
I mean, people have like graduated from high school and gone to college and graduated from college since this thing.
I know. I have 4 grandkids now. I didn't have any when this started.
Now there's the telling one, right? Oh, wow. Well, you're right. I still need to go back and read in detail, but first we can say, and we'll give you, I did the screenshot of the rule status and the link to it so you can follow it so that you can see officially. We did mention this a couple of times, but we didn't do an episode on it. So the security rule is listed in there and it says that the priority is economically significant. It is a major change that they're doing, a major event, whatever they call it. The agenda stage is in long-term actions. I like that. Agenda stage of rulemaking, long-term actions. And this mandate thing, I don't even know. But it only has 2 dates. It has the date it was released is January 2025. And then the final action, it says 07/00/2027.
Yeah. So July 0 of 2027.
Sometime in July 2027 is when they're estimating it. And, who knows? Who knows? I mean, we know that security stuff needs to be updated and improved like 3 years ago, 4 years ago. So another year, who cares? It'll all be different by then anyway, right?
Yeah. Well, I'm hoping that they learn that they can't keep up with technology and they figure out a way to say, look, we've got to look at something different other than constant regulatory actions that take a decade to happen.
Well, I mean, you can't say the security rule took a decade. I mean, it really hasn't changed since it came out in 2005.
Yeah, that's what I'm suggesting is that the rate of increase of technology has been constant through that time, but we haven't had a change. So it can't stay stagnant for a decade is what I'm saying. It's gotta be something that's more living, so to speak.
Yeah. Well, but we see already with these 2 examples that if you're going to do it regulatory, that's not happening. So that's why it's so important what we're doing with HSCC, for the sector, by the sector.
And it is worth noting that the security rule, HIPAA, privacy, all of it, if you look at it, they all say this is the floor. And I think that's a good way to put this. Like, no matter how much you think this is the absolute best security because it's HIPAA security, it's still the floor. It's always the floor.
Yeah, it shouldn't be like what you're searching for. It should be above it. And there's a chart that I use, and it's like there's a line where before that line is you're, neglecting your obligation to comply with the standard, right? Just past the line means you're complying. You have to get much further until it means that you have a really good security system, a security program in place. So it is, no matter how you look at it, something that, granted, the good news is it has been able to adapt. If people were doing what they were supposed to be doing all along, which that's where we always start, things would be different because we wouldn't be going through as many of these issues cybersecurity wise. But to prepare in the next year, go through and make sure you're just doing what you're supposed to do today, which is what most people aren't. They're not. It's not that they're not going through it. It's that they're not doing it and they don't know what they don't know. Start with your SRA. Make sure it's a proper one. And, people give us one and it's a gap analysis. We just got another one recently. It was a gap analysis. That's what it was. Yeah, IT did it. It was pretty much a gap analysis. Yeah, we have a procedure for that.
But I bet you if you ask them, they paid for a security risk assessment.
That's
and
what
it
they
was
think
from
it
a
is.
technical standpoint. Again, we talk about this all the time. You're using the exact same phrase, but you're meaning something completely different from each other.
Right. So go get the ducks in a row that we're already telling you. And that is the vast majority of things that we'll probably go through have a lot to do with it defining exactly what some of that means, which is not changing what it means. May add some requirements for AI governance and what we can do on that front. But again, that's not going to be way far out of what we've already told you. But invest time in it now because it's not going to be pretty when it's time to do it. Unless, of course, you're close to retirement and you've got a plan.
Yeah.
Just kidding.
But yeah, when it does come out, we'll be here. We'll walk through it. Be careful who you listen to. Like I saw one person post on LinkedIn, like, oh, they're going to get rid of all the optional things. Like,
there are no optional things.
About? Yeah, it's never been optional. And, and this was a person that underneath their name was, HIPAA consultant. And I'm like, come on, God.
It's not optional. Now, what I always say is focus on the required things because when you're going through the things that are addressable, you may be able to handle them already the way you're handling them. But, if it's required, you got to do it that way. So let's focus on that if you've got nothing. But addressable standards, that doesn't mean you don't get to do them. It's just that you don't have to do them exactly to the letter. So anyway, all that security stuff, it's going to take a while. And stuff ain't coming. And maybe privacy will come first.
Yeah. So somewhere around July of next year, we'll talk about this again. So 300 and some, 50 something episodes from now.
There it is. But what we're trying to say is don't use the traditional HIPAA implementation strategy of discovering the deadline when somebody goes, have you finished the training? Because, what do you mean? What do you mean? The number of times that I anyway, moving along, there's no sense. We've had those soapbox rants before, and it's just not a good day for those. Let's talk privacy.
All right. So the privacy rule, we do know that when it does finally come out, there will be a 60-day date or time frame that you'll have to get your house in order. And then you'll have like another 180 days to comply with that. So basically you're looking at 8 months, 240 days after the final rule's published.
Yeah, you get 8 months before enforcement happens. You get 180 days before you're supposed to have complied.
Mm-hmm.
And then from that time, but technically 60 days after publication, it's effective. Unless they say something different, that's the way it works. And the fact, I don't know. I remember saying this and somebody goes, that's still out there. I'm like, yeah, believe it or not. I'm like, there's privacy rule. No. They're only talking about, no, it's that old. 291, David, 291. And what
I
episode
know.
is this? What is it?
Five something.
Well, 571.
571. Yeah,
Oh.
almost 600.
Oh, my word. Anyway.
Yeah.
So, it's old enough that people have forgotten and never even worked in the field when this came out. So it's time to pay attention. And, every covered entity may not be affected by everything. Business associates probably only affected by a few things, but they should be aware of what their covered entities are having to do in case they need your assistance in implementation. But for the most part, it's a lot of workflow, policy and procedure training. Big in policy, procedure updates and training. The list of things, everything from, you got the right of access, that's huge. We'll get into that. The records request forms, the intake process, and all the forms of when you're doing it, identity verification, fee schedules, website content, big. The NPP, that's the nice part of the whole thing, is what we don't have to do there. But it's a lot, really. It's about patients getting faster and more practical access to their records. Well, let's say this. Let me clarify. This is what the NPRM was about. We don't know what the final rule is going to be about. But we can assume for the most part, I think a lot of this will be there in some format. So all about patients getting faster access and more options to access their records, and that giving providers more flexibility to share information. So care coordination, family involvement, safety for both patients and others, giving some flexibility there even though I would argue a lot of that was already there for some things, but it's building in care coordination, which was a big issue with all the community resources that are available, being able to share information with them. And then, of course, it just is a list, all your workflows, your forms, your notices, the training. Some of the technology may need to be revised just based on how you're doing it, not, I got to get a new app. So the biggest thing to me, though, is this response time on requests for records. I think that's the one that deer in the headlights moment.
Yeah. When you look at it, you've got 30 days and, they're already looking at dropping that down, to 15.
Yeah.
So,
yeah. Yeah. Well, they have all of these enforcement cases. They've been on this for a while. Everyone should have this down pat now in their policies and procedures, but then there should. So the rule is, from the time the patient requests access to their records, you have 30 days to get it to them, or you get one opportunity to extend to a 60-day response by sending them in writing why you're not going to be able to get it to them. And so all they're saying is, we're going to reduce that down to 15 days. And then if you need to go past 15 days, you can ask for a 15-day extension to 30 days. And that's calendar days. Well, I've been telling people all this time, start practicing that 15 days is what you're shooting for. Shoot for 15 days while you've got the flexibility. You're shooting for that to be your regular number, and then occasionally it's beyond that. And, for those who may have listened to me, this may not be as painful if it does come through. But there are a couple of things in there where it actually says that the patient gets the right to view, take notes, and take photographs. And the covered entity may impose requirements to ensure that an individual records only gets the protected health information. They're not getting a whole bunch of other things. So they can control what they're able to take pictures of. But what's ironic is that my father he's had a lot of health things, and he's religious about paying his bills, but he only wants to pay what he owes because he knows he wouldn't be able to get it back if you pay him stuff you don't owe. He's not wrong. And they literally, anyway, long story short, they're showing him something on his records, and my sister goes, "Can I take a picture of that?" on her little clipboard, where she printed it out. And she goes, "No, you can't take a picture of this."
Why not?
Why? Well, okay. Well, can I have it? No, but I can make you a copy of it. And I'm like, did you just? I'm surprised my sister didn't get in trouble, because they had a power outage due to storms, and there's no air conditioning, and she's been with Dad for 5 hours. He's sick. It's not. Kudos to her for letting people live. But so we know there's going to be a training issue if that goes through, and I can't imagine that it's not going to go through. Just because if the focus is truly on giving people access, those kind of things are going to be included in there. You're not going to be able to charge people to take a picture, none of that stuff. But what you need to do right now is, with them putting August on that date, so there's more reason to believe that this is really happening, because the stage of rulemaking is final rule stage, and they have already had 4 of the EO 12866 meetings, and then there were 2 others that were scheduled they didn't even need to have. And those are the meetings where they go through and they're asking questions about it and making changes and the reviews and all of that kind of stuff. Well, that's done. So I really expect that this, if they're putting in July an August date, that it's probably going to be August. And it may be towards the end of August that it comes out, though. So this is what you need to start doing, is get your ducks in a row. All the quacks. Saying that in medical is just funny. But figure out if you're getting delays and you're not averaging less than 15 days on your responses. You bet. First of all, know what your average is. Second, figure out where it's delayed. And is calendar days, you don't want, what happens if something's sitting in an inbox? Well, they were on vacation and they emailed so-and-so. Well, I don't remember which group it was, but it was like, it was one of the enforcement actions, and it was ridiculous. They're like, "Oh, you have to email this person. No, you have to send this form to these people. No, you're going to need to email this person. No, you got to call these people." And they were just sending them on all these different, and essentially they were talking to different vendors every time. They're not going to allow for that. It's just not going to happen sorry, it was in the inbox. You need to be able to filter and deal with those. And a lot of people have a problem where it's across several systems because they got multiple EHRs.
Mm-hmm.
And those are fun. It's like, when you go into a site and they're like, "Oh yeah, we have that other computer back in the locked room." What? Well, yeah. It's an old computer, and you only get to go back there if you have the key or the code. And then only certain people know how to log in, and it's just to get records off of the old system. Okay, great. And don't worry, it's not on the internet. Where you got a Faraday cage. No, but, I guess it's good enough. If your vendor's handling it, do you know what your vendor has planned for any of this stuff? How do you handle weekends and holidays and vacations? And do you have like a priority thing? Like, is there like something that triggers like, this one's getting down, it's to 10 days, trigger something. Make it a priority, make it urgent, something like that. But that is, best case is they don't reduce it to 15 days. But they're going to likely do something to make that easier and faster for patients to get their information. So you need to be figuring that one out. Start with, right now, we don't have anything but the 15 days to work with. But, and you can't say, well, you've got to go to the portal. No, that is not the answer. You can. If you would like, you can go to the portal. That's the fastest thing. But a lot of these portals don't let you get your records.
Right.
So,
yeah. I mean, it's one of those things they need to think about now, as we've said.
David's like, well, we're done with this. Moving on.
We're done. I mean, how many more ways can we say it?
Yeah.
Figure it out now.
The next one is one of my favorite ones. HIPAA can't be used as an excuse anymore. Well, at least not as often. I'm still flabbergasted by the home health care guy that told me that they didn't provide sheets for the hospital bed because it was a HIPAA violation. And I thought for sure like something had happened in my brain. It had snapped for him. Did he say that? And I'm like, no, it's not. Yes, ma'am. That's what they told us. No, it's not. Not that I care, but it's not.
Oh, no. This is a hill I will die on.
No, thankfully, the dude's like, ma'am, I don't know, but they put it on the board. That's what we're supposed to say if anybody asks about certain things.
Well, I mean, who's going to argue with it? How many people know enough about it to argue? So they just, okay.
Yeah. Yeah, and that's what they're using it for. So, blame HIPAA. Stop. Just, what was the lady that told me she found a dog that was injured and takes it into the vet and calls and asks how, no, that's a HIPAA violation. I'm sorry, the dog has HIPAA rights. So, gonna need to narrow that out a little bit. I don't think it'll fix those cases, but it does give you broader permission for being able to share across community and social service organizations. When somebody gets out of the hospital, you can say here now, when they're getting out of the hospital, they're like, here are the people you can call. Right. And that's it. Now they could actively work and notify them, hey, so-and-so has had these procedures and they're coming home on this day and they need some services. Ta-da! I mean, simplicity and actual patient care being the focus and not having to draw that line so sternly. But also family members and caregivers, there's some stuff there. And this is the big thing, is it's changing the standard from use your professional judgment, which a lot of people are like, that could get my license involved. And no. So I'm going to err on the side of caution. Instead of saying that, it's good faith belief in some of the ones where it's really become important. So that is legal wording, and that will matter. And that's going to require everybody getting educated and changing the term serious and imminent threat. And that imminent, everybody's like, do I know that it's about to happen? Nope, then it's not imminent. They changing that to serious and reasonably foreseeable threat. And that's huge in mental health. That's huge.
Yep.
There are cases also when it comes to addictions and those kind of things that it might matter. And being able to work with family members and caregivers in certain situations because of serious and reasonably foreseeable threat, and you have a good faith belief that it exists, we can provide better care. But again, it's always about patient care. It's not make this person go away. So I'll just tell them it's about, is it right for the patient? Caring for the patient. And that's where it's going to land. And there's some sticky situations. I already see it becoming a mess. Big mess.
Yep.
Because here's the kind of things you need to start thinking about, because I can't imagine this stuff is not going to be in there, because it's a key element. I think it's like improved care coordination is in the title. But who's going to be allowed to make these decisions, and how are you going to train them? How are you going to document the reasoning? What if state law is more restrictive than HIPAA is? What do you do? Because that one's going to become very, very tricky, particularly in pediatrics and young adult care. When you turn 18, it gets complicated. You know, how do you know it's the patient's preference? Was somebody in there in the room with them, pressuring them on their preference? Are you asking them, you know, to make decisions and allowing them the comfort that it's okay? And it's not a permission to share everything. Blanche, you can't go tell grandma who you saw at work. Yeah. So it's going to be tricky. Training them that they can do things that they thought they couldn't do, but that doesn't mean that you can do everything you thought you couldn't do. How are you going to do that?
With a lot of training.
I see so many problems, David.
Yeah. Well, part of it's going to be, for some organizations, it's like, okay, we're not doing it this way anymore. We're going to be doing it this other way. And then, you know, it's harder to change a habit than to create a habit. So that's going to be, it's going to be interesting to see the whole, well, we've always done it this way, folks. And it's like, yeah, but we just had training and we don't do it that way anymore. I know, but we've always done it that way. I can't remember.
What did they tell us yesterday? Does anybody remember? It's
just do it the way you've always been doing it. Don't worry about it.
God, we know those conversations are going to happen, right?
Of course they are.
Yeah. So you're going to have to figure out all those kind of things and start thinking about them now. Just sit down, pick one of these things and start going through it. Good news, though. Good one. They get to call it deregulatory because it's allowing you to talk to people you couldn't before. And the big thing, no more having to sign that form.
Yeah.
Just take it off. Not that anybody can give you the MPP when you ask for it anyway.
Well, I always love the ones you go in. It's like, we haven't seen you in 6 months. We need you to fill out these 4 pages. I'm like, what? Now, some of that's, you know, their process. Some of it's stuff they come up with, but inevitably there's a HIPAA form. I'm like, why am I signing this NPP again? Well, you have to sign it every 6 months. I'm like, no, you don't. Why am I signing this thing again?
No. And then you ask, my favorite is to ask to see it, and they don't even know where it is.
Yeah, I had that on it was a chiropractic visit a couple of years ago. And it's like, it says here that if I request to see it, that you could show it to me. And this lady's like, I don't know where that is.
Yeah. So you're going to need to fix that problem, because the flip side of is that you can just now ask questions and get answers and be able to discuss it with them. So you got to know what to do if people start asking questions about access to their health care, how to file a complaint, how to get a copy of the NPP if they want one. Telling me it's in that giant poster on the wall is not going to help solve that problem. And my favorite is it's in the little binder where you got to touch it in a doctor's office. And even worse, a pediatric one. I'm like, I don't want to touch. Can I have some gloves? I need a mask, some gloves. Better suit me up. Give me all the scrubs. Put my shoes, all that stuff. I got to open this binder. But, you know, they can set a designated person, and you can say, okay, this is who you got to talk to. And, it could be, here, call this number and ask these questions to, I can see people now asking Carden, are you going to do that? Are you going to let us call? Oh, no. Anyway.
You can talk to our bot.
That's it. We've got a nice bot that we manage. But there's several changes to the MPP, right? And it's not that anybody knew what was in it, but I believe part of your training with all of these changes is that everybody reads it and you actually go through and discuss it, because a lot of this stuff is now going to be in the NPP to explain it, and by an NPP for those notice of privacy practices. Sorry. I hate it when I forget to do that. But if you plan your training around reviewing the MPP, you get the MPP done and you start doing little mini sessions on discussing what the things are in the MPP, it's a whole new ballgame, because now you're going to train based on this document that, it's on your website. That's another thing. You got to update the website with all this stuff. So there's a lot of stuff that'll have to happen. And David's thrilled that very little, if any of it, has anything to do with being a business associate or the technology he supports.
I am thrilled.
Because next July, it ain't going to be parody. Yeah. So if you start thinking about where these impacts are, and, sharpen those policy and procedure pencils. Because, come on. I'm tired. Anyway, get out your crayons and paper, because you're going to be doing a lot of policies and procedures. And before people even start, you're not just going to tell AI to write your new policies. No. You're not just going to tell them and put it in a binder and off you go. You need to understand what's going in them and that it matches your actual workflow. Please. Because I see it happening already.
Of course.
We should just make a list of all of the nightmares that we start having.
Will that be for October's episode?
Oh, brilliant. I love it. But that's enough. That's enough on pull the stuff. And if you just start doing these things, worry about how you're letting people ask for records should meet the requirements, what you're charging needs to meet the requirements, your turnaround time, you better know about that. And then also, who's making decisions when these start changing on who can talk and who can know things? You're wanting to control that, I promise. Because people will complain if you get a little too loosey-goosey. So
right.
It's at least where you should get started, because maybe you'll need them. Don't know.
Yeah.
Don't know.
All right. Well, hopefully we'll have the privacy changes coming out here in a few weeks, and then we can speak exactly on what the changes are. The security rule stuff, probably won't be talking about it for a little while. We're going to kick that can down the road, Yeah. But the thing about a security rule is when they pushed it out, which, you and I knew it wasn't going to be May anyway, but I couldn't help but think it's kind of like the anticipation of pain is worse than the pain itself. It's just going to hurt longer now.
It's definitely the problem. There it is.
Yeah. Well, anyway, That's our show for today, folks. You hear my phone ringing in the background?
That's right. Already getting complaints.
I know. So until next time, remember, for Donna and myself, the HIPAA is not about compliance. It's about patient care.
You've been listening to the Help Me with HIPAA podcast, hosted by Donna Grindle and David Sims. The show created to help you with HIPAA. For more information or to ask us a question, visit our website at helpmewithhipaa.com. Neither Donna Grindle or David Sims are attorneys, and they do not offer binding legal advice concerning regulatory compliance. The information in this podcast should not be relied upon or construed as legal advice in any way. Consult your attorney for legal advice concerning compliance with HIPAA regulations.